let's talk about how Dennis Rodman changed the tax world and the tax code and personal injury law. It's actually a very fascinating thing. I actually like this case simply because it's something that we can actually see what happened,
Right.
and it impacts every single state in the union because it's federal law,
Mm-hmm.
and I think it's something that's underappreciated by guys who do what I do, guys and gals,
Yeah.
men and women. So
All right, so let's kick it off. Those of you who are actually able to see us, right, versus the people who are just listening, I'll go ahead and describe what's going on as we bring up this videotape. So what is this? Like 1995?
actually, it's January of '97.
Okay.
It's the Bulls versus the Timberwolves,
Okay.
and it's Dennis Rodman trying to get a rebound, and he goes beyond the baseline and hurts himself, and his foot is right next to a guy named Mr. Amos,
Yep.
and he decides to just kick him, and then the other thing he does is he stands over and he tries to intimidate him,
Right.
and you can see Mr. Amos on the ground there rolling over, and even one of the announcers says something about, this is going to be a payday of some sort, which was, I thought, kind of a derogatory remark. But, what Rodman does there is pretty deliberate. And, I've seen interviews where he says sort of the heat of the moment kind of thing. It just sort of happened. And, that's still pretty mean. I mean, it's still pretty powerful to
Right.
just sit there and get kicked and then be, looked down upon and growled at and then have people pull him away. And then you see Rodman in the video.
Yeah.
He just kind of
Rolls his eyes.
exactly
Like, oh, you got to be kidding me.
yeah, exactly, and
Yeah.
and yeah, it's sort of insult to injury.
Right.
You and I talked a little bit beforehand. Even though the injury is modest, the fact that the injured party contacted a lawyer so quickly kind of made me go, well. But I'm always one to advocate getting counsel early to handle things, but it was pretty clear what happened. It was all on video.
Yeah, exactly. The whole world saw it.
Yeah. But the guy got hurt, and he was humiliated. He's actually taken from this scene on a stretcher, and he's taken by ambulance
Right.
from this location. So that's really embarrassing, and when people fall or when people get in accidents, all of a sudden they're embarrassed by the fact that they were the victims, and it's a weird society thing. We look at people like, well, you shouldn't have been in the first place. Really?
Right.
That's not the way it works. You shouldn't have kicked them. Shouldn't have done that. But nonetheless,
Yeah, I think I read part of the case that he actually had some pre-existing conditions or
He did.
pre-existing injuries before actually getting kicked in the
yeah.
groin.
What happened was he had a pre-existing back condition that they were wondering if it was aggravated or not. And having a pre-existing condition is not a compensable damage, but having that condition worsened or aggravated is compensable. So at least under California law. I'm sure some other states might be looking at this.
Yeah.
But under California law, an aggravation of pre-existing condition, that change in the condition is compensable. Now, under California law, you don't have to make that underlying condition better. You just have to make it as good as it was prior to the incident. Right. The interesting thing also about the Amos case is they resolved it within 6 days. That's kind of a speed record.
Yeah, it was a quick settlement, right? Rodman basically wanted to cut the check and get it over with. And
Exactly.
Get it out behind him. Yeah.
And what happened was, in the process, they had come up with a number, and that number was supposed to be confidential.
Yeah.
But it's not. It's $200,000.
How'd that happen?
Yes. What happened was an audit.
An audit, and then they appealed it, and then it went to
exactly.
US
So
tax court.
what happened was he paid them this $200,000, and under the Internal Revenue Code, I think it's 104A2. Is that right?
104A3 is the one about personal injuries.
Okay. Yeah. And basically, when you have an injury, a physical injury caused by something, there's compensation. That doesn't become income, correct?
That's correct. Yeah, exactly.
And that means that the recovery in an accident generally is non-taxable.
Right.
There are some exceptions.
Correct.
One of the exceptions was created by this case, or at least crystallized in this case.
Yep.
When you pay someone damages, but you also ask them to be confidential about the damages.
Mm-hmm.
You're not just paying them for their harm, you're also paying for them to stay quiet. It's sort of a contract, a service, not to open your mouth.
Yep.
And that's what the IRS took issue with on the Amos case. They said, well, you have this income, and since you did not differentiate in the settlement agreement how much of it was for your pain and suffering and how much of it was for your confidentiality,
Right.
We're going to say $1 for your injury.
Yeah,
and
auditor's great.
Yeah, auditors did that. And the other $199,999 is all taxable income.
Yeah.
Which also made me scratch my head because he did not receive all all $200,000. He had to pay some expenses. He had to pay medical bills. He had to pay an attorney.
Yeah.
What that guy actually netted, what Mr. Amos actually netted, it didn't go into his bank account. The $200,000 didn't go to his bank account. The portion after all the other charges would have been. So to me, that was like, I don't think that other stuff would be taxable because he never received or had a right to receive a portion of it. So to me, the taxable portion of it, or at least the portion in question, shouldn't have been $200,000 from the get-go. But that's what they said. And then they went to an appeal. They went to tax court, and the tax court said, well, we actually think that some of it is for your pain, more than $1 worth, and some of it is for you to not disclose. And I think they went with a 60-40 split. 60% of it, or $120,000, was for your injuries, and 40% of it, or $80,000, was for you not to tell the police anything, not to tell the papers, not to tell the media.
Right.
That not telling the police thing, actually, that's part of it, because Mr. Amos had filed criminal charges against Mr. Rodman for the incident. It was a battery. It really was.
Right.
And absolutely, it should have been criminal. I mean, he had no right kicking a guy. That's a crime. But part of the deal that Mr. Rodman was trying to make was that he not cooperate with prosecutors, because if they don't have a victim, there's no way to prove the crime.
Right.
Well, I'm not a criminal attorney, so maybe there is. I don't know. By and large, though, I would say without him testifying, how are they going to be able to prove it? So that was part of what he was buying. Also, part of what he was buying was he didn't want this stuff splashed all over the world.
Right.
Well, wow, because of that confidentiality clause, it actually was the opposite. In 1997, that came down, and as a result, there is now taxability in otherwise non-taxable recoveries in personal injury cases if there's a confidentiality clause. So one of the things that I do in my job is I negotiate settlements. I negotiate with all types of people. And one of the things now I negotiate for the past, 15 years has been, I've been involved for 20 years, so it'll be 20 years, is now whether or not there's a confidentiality clause. And when I go to a mediation or I go into some sort of settlement, I'll tell them right off the bat, we will not engage in a confidentiality clause because of the tax consequences.
Yeah.
And there was some holdings, but there were some suggestions as to how to circumvent making it all taxable. And one of the suggestions that I had seen or been told is, well, why don't we just differentiate? We'll make X number of dollars for the injury and X number of dollars for the confidentiality.
Yeah.
Okay, well, I don't think a case has really exactly said that's doable. I know that they have intimated it. They've kind of said it in this case a little bit.
Right.
But I didn't see a case on point yet. There may be.
Right. Well, it's a matter of if you've already placed a value on there, you're going to have a better chance of that number holding up. But the IRS can always come back and rule against you and reallocate things.
Correct.
And so you might also, I'm not an attorney, but you might also want to put in a stipulation that if an audit were to occur and they actually come back and reassess that line, right? So like you thought it was 60-40, they think it's 50-50. Well, then, whoever actually paid out the settlement would come back and pay the tax on that.
Yeah, it's an indemnity clause,
right?
Indemnify and defend. And
there you go. Yeah,
it's really hard to get them to agree to an indemnity.
They want you to go away.
Oh yeah, and they ask for indemnity from me all the time.
Yeah.
And frankly, if my client has an unpaid bill and somebody sues the defendant for that unpaid bill,
Yeah.
my client is responsible.
Mhm.
So we do indemnify for that because we know that we have to cover the bills. However, I will not indemnify for other things. I
Yeah.
will not defend them. I will not defend them for claims that are brought that have no merit.
Mhm.
I will not do any of my client will not agree to that. And that's always a point of contention.
Right.
As far as the confidentiality, that's a point of contention as well. We actually have, I agree with your assessment that, let's say a case goes to verdict
Mhm.
and you have a fixed number. That helps to do things like that. Or
Right.
if you have an arbitration, you have a fixed number. One of the other suggestions that came along was, okay, well, if they want it taxable, increase the settlement.
Money solves everything, right?
Exactly.
Yeah.
But again, that's something that's going to see a little bit of pushback from most defense positions.
Yeah.
But the Rodman case was kind of a landmark case, and I just don't think a lot of people are it's on their radar. In fact, when I go to arbitrations or mediations or I bring it up with people when we try to resolve cases, and they ask me about the confidentiality clause. I don't know if they're being deliberately obtuse that they don't know about this case, or they really don't know about this case.
Yeah.
And you have to be in the know, because if your clients are relying on your knowledge and you're unfamiliar with this, it's important to know.